Oftentimes, insurers are the lifeline for policyholders in their times of need. But what happens when a delay in resolving a claim is viewed as either unfair or unreasonable? How can we distinguish between operational challenges and bad faith? What constitutes bad faith in the eyes of the law and regulators, and what can insurers do to avoid a policyholder's perception of bad faith? We'll break down the legal and practical definitions of bad faith, discuss the common causes of claim delays, and help insurers avoid legal problems with Dickie McCamey insurance attorney C.J. Haddick on this edition of the DMC Report.
From the offices of Dickie, McCamey, and Chilcote, this is the DMC Report.
We're talking about insurance bad faith with the author and editor of the insurance blog Bad Faith Advisor. C.J. Haddick is a shareholder and the managing attorney of Dickie McCamey's Harrisburg, Pennsylvania office. He practices in the areas of insurance coverage and insurance bad faith litigation and insurance fraud. He also provides insurers throughout the U.S. with legal coverage opinions on all types of policies, ranging from homeowners and auto insurance, commercial general liability, professional liability, commercial excess, and workers' compensation policies. And CJ is joining us today from his office in Harrisburg, Pennsylvania. CJ, it's good to see you again.
Good to see you, Bob. Good to be with you.
Let's start with some legal definitions here. What is the definition of bad faith, and how does it differ from a simple delay in processing or a dispute in settling a claim?
The simplest way to put it, I think, and the definition I keep coming back to after doing this for 30 plus years, is that bad faith is really any claims-related conduct on the part of an insurer which lacks a reasonable basis. Now, sometimes it helps when looking at what bad faith is to look at what it is not. It is not a mere disagreement over a claim with an insured. It is not negligence in handling a claim. Bad faith is something beyond that, and the analysis is usually, does the insurer have a reasonable basis to either handle a claim a certain way or make a decision on a claim a certain way? That is the easiest way of looking at it, is whether or not a reasonable basis exists for an insurer's position.
Are there specific statutes or regs that define what constitutes bad faith?
Yeah, in Pennsylvania, and really in a lot of jurisdictions, there are two bases of law, really. There is, Pennsylvania does have a bad faith statute, which sets forth that a court can award damages such as interest and punitive damages, attorney's fees, if bad faith is established. Now, the statute doesn't itself define what bad faith is, and that's defined in what we call the common law, or the case decisions that come down, where it is a very fact-intensive kind of analysis, where the courts have to look at how a specific claim is handled, and again, whether or not there is a reasonable basis for it. So there is a bad faith statute, but there is also common law, case law, defining what bad faith is in Pennsylvania.
All right, so what kinds of conduct on the part of the insurer constitutes bad faith, as opposed to just a disagreement or a dispute and settling a claim?
There's another statute which kind of helps with that, the Pennsylvania Pennsylvania Unfair Insurance Practices Act. It sets out conduct on the part of the insurer which is a violation of the act. Now, it does not necessarily mean it's bad faith, but courts often allow evidence of violation of the UIPA as proof of bad faith. And the Unfair Insurance Practices Act addresses things like insurance companies misrepresenting policy benefits or misrepresenting facts relating to a claim, failing to answer a claim within a reasonable time, compelling policyholders to file suit when there's really no reasonable grounds to deny a claim, and attempting to settle a claim for an amount that is less than what is considered reasonable In the business, sometimes it's referred to as lowballing. And that is not to say that an insurance company and an insured can't have a reasonable dispute about what a claim is worth. Just because an insurer doesn't offer what an insured is demanding doesn't necessarily mean there's bad faith. There can be an honest, reasonable disagreement among the parties about what a claim is worth. And so it's those kinds of things, those kinds of examples, which we see in the case law. Oftentimes, the two biggest that we run into, and they're often seen together actually, is delay in processing a claim and then an unreasonable offer or an unreasonable denial, to take it even further.
So you've been doing this a long time. In your experience, are there red flags to look out for in claims handling that can expose an insurer to bad faith claims?
Yeah, the key to handling it all, in terms of what my job is, working for insurance companies, is what is documented, what is actually in the claims file. Because if it's not documented in the claims file, that creates problems for the insurance company. And so red flags would include things like things being omitted from a claims file, activity logs, things like that, where you look at a claims file and look at the activity logs and so on, and you can't get a handle on the insurer's thought process. So one red flag, the biggest red flag to me, is the claims file lacking in some way in terms of being able to trace the insurance company's thought process as it handles the claim. Is it being handled promptly? Is it being handled fairly? Are the numbers, in terms of valuing a claim, putting reserves on a claim, are the numbers reasonable in light of the injuries or the property damage, depending on the type of case? And so the red flags or absence of red flags, the first place I will look is the insurance company's claims file, and obviously speak with the frontline claims adjuster. And oftentimes it's in that initial stage where you will see things that pop up that strike you as possibly bad faith. And so it really begins and ends with the claims handling process. And if it's not documented in the claims file, an insurer is going to have trouble down the line having to fill in the blanks. So gaps are a red flag as well.
So what's the burden of proof for the policyholder to meet to prove bad faith in court?
Yeah, in Pennsylvania, and it's different in different jurisdictions, although it's named differently, but oftentimes it means the same thing. In Pennsylvania, the burden of proof in a bad faith case is having to prove the lack of a reasonable basis by the insurer by what's called clear and convincing evidence. Now, clear and convincing evidence in itself, I don't even know what it is if I look at it just in the abstract, but clear and convincing evidence is a burden of proof that lies somewhere between preponderance of the evidence, which is a standard burden of proof in civil cases, and evidence beyond a reasonable doubt, which is the standard in criminal cases. It's in that no man's land between the civil burden of proof and the criminal burden of proof, where we find the clear and convincing evidence standard. And so it's something more than a preponderance, but it is not as it does not require as much, we should say, as in a criminal case where proof must be made beyond a reasonable doubt by the prosecution. And to be honest with you, doing it 30 years and dealing with all kinds of judges, I'm not sure. I think there's a general sense, Bob, that of what the clear and convincing burden of proof is, but that's also, like reasonableness, a little bit in the eye of the beholder. So depending on the judge who's reviewing the case, which oftentimes it's reviewed by way of pretrial motions to dismiss, it depends on what the particular judge thinks clear and convincing proof is. But So it's a little bit of a hybrid burden of proof, and does make for some interesting challenges in terms of, and also in cases of jury trials, instructing the jury about these kinds of things.
So far we've been talking about the insurance company. What about the insured? Uh, the policyholder's behavior has to have a role in all of this, right? I mean, things like delays in getting back information that's been requested. How does that impact the court's determination of bad faith?
Well, I'm glad you brought that up, because that's kind of a pet project of mine. It has been, since I started handling bad faith cases. Both sides in an insurance claim, the insurance company and also the insured, have a duty of good faith and fair dealing. And when I first started to do this, that was kind of overlooked. Really, the only scrutiny of any conduct was the scrutiny of the insurance company's conduct. And that's still predominantly the focus. But there is case law in Pennsylvania, some of which I was involved in creating, for better or worse, which says that the insured can be guilty of what's sometimes referred to as reverse bad faith. Time limit settlement demands. For example, in a personal injury case where an insured will make a time limit settlement demand of 30 days, but doesn't provide a complete set of his medical records, or won't sign authorizations to get medical records. That is kind of what we call a bad faith setup, where insureds and enterprising lawyers for insureds attempt to put the insurance company in a position, in a box, where it's forced to respond to a time limit settlement demand, but it's not given all of the information. That's a good example. Another example is in bad faith cases where delay is an issue. One of the ways we defend insurance companies is we actually go back and create a calendar to assign who's responsible for what delay. In other words, if a claim takes 18 months to handle, for example, and the insured is responsible for half of that, 9 months of delay, we then, as part of defending the insurance company, point out that the claim that there was an 18-month delay is not accurate. 9 months of it was due to the insured. And that sometimes can constitute reverse bad faith as well. And it's not, in my experience, as I said, in the roaring 2000s, it was much more, I think, voluminous. But it still occurs, and it still has to be looked at. Failing to cooperate with an investigation, by the way. Your insurance policy, any insurance policy, says the insured has an obligation to cooperate with the insurance company in the course of investigation. I've had cases, usually, most commonly, I should say, in arson cases or fire cases. Shouldn't say it's an arson case necessarily. It's a fire claim that potentially is the result of arson, but sometimes you'll get insureds who get skittish, obviously, if there are some questions about the cause and origin of the fire, and if they fail, to example, to submit to an examination under oath that's required in most policies, that can constitute bad faith conduct on the part of the insured. And that is always germane. There's some question in the case law as to whether it's a complete defense or how it fits, but it's certainly, in the cases I've litigated, it's certainly germane and relevant, especially in those delay cases. So an insured has a duty to cooperate. His failure to discharge that duty in a bad faith case may be relevant. And that's generally when we examine what role reverse bad faith has.
We're talking about insurance bad faith with attorney C.J. Haddick from Harrisburg, Pennsylvania. So, C.J., before we get to the point where litigation becomes necessary, are there options to resolve disputes over delays or the perception of bad faith?
All right. Well, I will never let a podcast finish without me making a commercial. of some sort. And in terms of, pre-litigation, sometimes insurance companies can save themselves tons of time and money and aggravation by involving counsel in challenging claims, not run-of-the-mill claims, but in challenging claims by getting legal advice during the life of the claim itself. This enables myself or any lawyer who represents an insurance company to sort of provide some guidance and say, well, you need to look into this, you need to look into this, and you have to do it in a reasonably prompt amount of time. Or sometimes we will give guidance on what an injury is generally considered to be worth. We'll take a look at liability analysis. And so a lot of times it can be avoided by getting some good advice and good help during the claims handling process itself. But to the extent that there becomes a dispute, even after a complaint is filed, a big trend in my experience now is that lawyers as a group are tending to be more open to ADR, alternative dispute resolution, as a way to avoid the time and cost and risk of litigation. So if an example of alternative dispute resolution would be mediation. It's non-binding. The parties appear before an objective mediator who evaluates the case and attempts to help the parties try to work toward a resolution, whether that's a settlement or usually it is a settlement, coming up with the right number, for example. And insurance companies will sometimes take advantage of that in the right case. Some cases are not good candidates for mediation, for example, but some are. And it's non-binding, so there's really nothing to lose. And in terms of cost, you have to pay a mediator and you have to pay a lawyer for their time to participate. But when you compare that to what an insurance coverage litigation costs or what bad faith litigation costs, it is a bargain. And so in the right cases, we make recommendations to our insurance company clients to at least be open to it if the other side proposes it or is interested in it. Because in some ways, once you throw caution to the wind and set off on a course for litigation, if you're going to go the entire distance, your fate gets taken out of your hands at some point. It's put into the hands of a judge or a jury or both, and you no longer have control. The advantage of mediation, for example, is that you still have control over your fate. And I'm noticing it. It was not very, it was not in great use when I started, but nowadays, lately, over the last 10 years, I would say, it's becoming more and more common. And it works to the advantage of both parties, the insured and the insurer, because there's a chance to resolve the claim without having to spend the time or the money on litigation. So that is always an option.
Technology is taking over just about every aspect of society and the economy. Does technology pose any bad faith risks to insurers in handling claims?
I would say yes, it does. And in sort of thinking about this particular question, I was reminded of the fact that artificial intelligence and insurance is by no means a new thing. When I was starting out, maybe 5 or 10 years out, insurance companies did have computer programs, algorithms that assisted them in valuing claims. A lot of the major national insurers had computer systems, software, that you would input facts, data, medical expenses, etc., and it would spit out a value. Courts generally were not super thrilled about that because it sort of takes the judgment, human judgment, out of the claims evaluation process. And so I would say my advice to insurance companies today for artificial intelligence would be the same that it was 15 or 20 years ago, which is just have to be careful that our AI is a wonderful tool, but at least at this stage of the technology and this stage of where the law is, you cannot just turn things over to AI and not still engage. And so it's a tool, it's a source of input, but in order to avoid any bad faith exposure, I think still, this goes back to the claims investigation discussion, companies still have to have human interaction, evaluation. AI is a great tool, but it is only a tool. It is not the end-all, be-all in terms of evaluating insurance claims, and insurance companies need to be mindful of that when they're deploying that kind of technology.
Well, CJ, as always, thank you very much for your time. Great advice, great insight for insurers looking to reduce their risk of bad faith claims. For more information about insurance bad faith or other opinions that CJ has offered in public, you can see his blog, thebadfaithadvisor.com. CJ Haddick from the Harrisburg office of Dickie McCamey. Thanks again, my friend.
Thank you for having me, Bob. I appreciate it.
From the offices of Dickie, McCamey, and Chilcote, this is the DMC Report.